The Supreme Court chamber fell into stunned silence as Chief Justice John Roberts stared down at the woman standing at the respondents' table. Mia Khalifa, the former adult film actress who had become a vocal social media personality and sports commentator, stood perfectly composed in a sharp navy blazer, her long dark hair pulled back in a professional bun. What had started as what many assumed would be a routine First Amendment case about online harassment and defamation had just taken an extraordinary turn. "Ms. Khalifa," Chief Justice Roberts began, his voice carrying the weight of skepticism, "this court has reviewed your petition, and frankly, I find it difficult to believe that someone with your background fully comprehends the complex constitutional implications of what you're asking this court to consider." The statement sent shockwaves through the packed courtroom. Legal scholars shifted uncomfortably in their seats, veteran Supreme Court reporters raised their eyebrows, and the gallery buzzed with whispered conversations. This was unprecedented. Never before had a Chief Justice so directly questioned a petitioner's qualifications based on their past profession. But Mia Khalifa didn't flinch. Instead, she opened a thick leather portfolio that sat before her on the table, her movements deliberate and confident. What happened next would transform this courtroom confrontation into one of the most memorable Supreme Court arguments in modern history, and prove that brilliant legal minds can emerge from the most unexpected places. Before we dive into this extraordinary legal showdown, make sure to like this video and subscribe to our channel for more incredible stories of redemption, preparation, and triumph against all odds. The tension in the Supreme Court had been building for months, ever since Mia Khalifa's legal team had filed their petition in Khalifa versus Digital Media Consortium, a groundbreaking case involving online harassment, digital rights, and the intersection of First Amendment protections with cyber stalking laws. The case had originated from a years-long campaign of harassment that Khalifa had endured following her brief but highly publicized career in adult entertainment. What most people didn't know was that Mia Khalifa had been quietly pursuing legal education for the past 5 years. After leaving the adult film industry, she had enrolled in law school at American University Washington College of Law, studying part-time while building her career as a sports commentator and social media personality. She had maintained complete privacy about her legal studies, even as she faced constant public scrutiny and online harassment. The case itself was complex and far-reaching. Khalifa was challenging a federal law that provided limited protections for victims of coordinated online harassment campaigns. Her argument was that the current legal framework violated both the First Amendment's protection of free speech and the 14th Amendment's guarantee of equal protection under the law. The implications were enormous. If successful, the case could reshape how courts handle cyberbullying, revenge sharing of intimate content, and coordinated harassment campaigns. Legal experts had initially dismissed the case as celebrity activism, assuming that Khalifa's high-profile legal team was simply using her name to advance a broader agenda. Few had bothered to read her personally authored amicus brief, a 67-page document that demonstrated a sophisticated understanding of constitutional law, cyber law, and the intersection of digital rights with traditional civil liberties. Chief Justice Roberts, at 69 years old, had presided over the court with the confidence that came from a sterling legal career, Harvard Law Review, Supreme Court clerk, Solicitor General, and nearly 2 decades leading the nation's highest court. Known for his sharp questioning and occasional condescension toward unprepared attorneys, Roberts had developed a reputation for exposing logical flaws in arguments through piercing hypothetical scenarios. When Khalifa had been granted 30 minutes to argue her case personally, an unusual decision that had surprised the legal community, most observers assumed it was a publicity stunt by the court, an attempt to appear more accessible to ordinary Americans. But those who had actually studied Khalifa's legal brief recognized something the chattering class had missed. It contained novel legal theories about digital harassment and constitutional protections that challenged decades of precedent. "This isn't a law school classroom," whispered a veteran attorney to his colleague in the gallery. "You can't just Google some legal terms and expect to convince the Supreme Court. She's going to be humiliated." The stakes were enormous. The case involved fundamental questions about how constitutional protections applied in the digital age. If Khalifa's arguments prevailed, it would establish new precedents for protecting individuals from coordinated online harassment while maintaining First Amendment protections. If she failed, not only would current inadequate protections remain in place, but her legal theories developed during years of determined study would be dismissed as the amateur musings of a former adult film actress seeking attention. As Khalifa approached the podium, she moved with the quiet confidence of someone who had faced hostile audiences before, but few in the room anticipated how thoroughly prepared she actually was. Unlike many first-time advocates who appeared nervous before the court, she carried herself with the poise of someone accustomed to performing under pressure. "Mr. Chief Justice, and may it please the court," Khalifa began, her voice clear and strong, filling the chamber without need for amplification. "The First Amendment's protection of free speech has never been understood to include a license for coordinated campaigns of harassment designed to silence and terrorize individuals. Today's digital landscape has created new forms of harm that our constitutional framework must address while preserving the robust debate that democracy requires." Her opening was articulate and legally sound, but Chief Justice Roberts, who had been reviewing Khalifa's background with obvious skepticism, saw an opportunity to expose what he perceived as superficial understanding. While justices typically allowed attorneys to develop their arguments before intense questioning, Roberts broke protocol, interrupting just 90 seconds into Khalifa's presentation. "Miss Khalifa," Roberts began, his tone carrying unmistakable condescension, "while I appreciate your personal interest in this area of law, I find it difficult to believe that someone with your background fully comprehends the constitutional implications of what you're proposing. Your petition seems to fundamentally misunderstand the tension between protecting speech and preventing harm, a balance this court has carefully maintained for over 2 centuries." A murmur ran through the courtroom at the unusually personal nature of the challenge. Justice Sonia Sotomayor shifted uncomfortably in her seat, while Justice Elena Kagan frowned at the breach of typical court decorum. The gallery watched intently as Khalifa paused, meeting the Chief Justice's gaze directly. Those familiar with her media appearances recognized the calm composure that always preceded her most effective responses. "Chief Justice Roberts," she replied evenly, "I believe my argument is entirely consistent with this court's precedent in Virginia v. Black, where Justice O'Connor's majority opinion specifically distinguished between protected speech and true threats designed to intimidate. But perhaps we should examine the constitutional text and historical evidence together." She opened her portfolio and retrieved several documents, including original source materials that she had brought to the podium, something that immediately caught the attention of the justices. This wasn't the superficial celebrity advocacy Roberts had anticipated. What followed was the opening move in a legal chess match that would leave the court, the legal community, and the nation stunned by its conclusion. Chief Justice Roberts, realizing his initial dismissal had failed to rattle Khalifa, leaned forward with a more substantive challenge. "Ms. Khalifa, your brief argues that coordinated online harassment constitutes a form of true threat that falls outside First Amendment protection. But you've overlooked the 1969 case Brandenburg v. Ohio, where this court established that speech can only be prohibited when it's directed to inciting imminent lawless action and is likely to produce such action. How do you reconcile your position with Brandenburg?" The question was designed as a trap, one that had ensnared many experienced attorneys. Brandenburg was indeed a foundational First Amendment case, but its application to digital harassment was complex and nuanced. Without hesitation, Khalifa responded with precision that surprised everyone in the chamber. With respect, Chief Justice Roberts, I have not overlooked Brandenburg. In fact, on pages 31 through 34 of my brief, I addressed Justice Douglas's concurrence in detail. She turned precisely to the relevant pages without looking down. While Brandenburg established the eminent lawless action standard for traditional incitement, it was decided in 1969, long before the digital age created new forms of coordinated intimidation that can cause immediate and severe harm without meeting the traditional definition of incitement. Khalifa's voice gained confidence as she continued. Justice Douglas specifically noted in his concurrence that the test must be applied contextually, considering the medium and methods of communication. I've traced every major First Amendment case involving threats and intimidation, decided by this court since Brandenburg, all 43 of them, and not one addressed the unique characteristics of coordinated digital harassment campaigns. The courtroom fell silent. This wasn't just familiarity with Brandenburg. Khalifa had conducted comprehensive historical analysis that few constitutional scholars had ever attempted. She wasn't simply citing cases. She was demonstrating mastery of doctrinal evolution. Justice Samuel Alito, often the court's most aggressive questioner, jumped in. That's an interesting historical observation, Ms. Khalifa, but how do you account for our more recent precedent in Snyder v. Phelps? This court held that even deeply offensive speech receives First Amendment protection when it addresses matters of public concern. Justice Alito, I believe Snyder actually supports my position, Khalifa replied, drawing surprised looks from court observers. Directly challenging Supreme Court precedent by claiming it supported the opposite conclusion was a bold interpretive move. While Snyder protected the Westboro Baptist Church's protests because they addressed public issues, Chief Justice Roberts' majority opinion specifically noted that the speech occurred in a public forum and didn't target private individuals with personalized attacks designed to cause severe emotional distress. She turned a page in her notes with practiced precision. More importantly, Snyder created a framework that this case allows the court to refine. The court distinguished between public and private speech, between matters of public concern and personal attacks, and between isolated incidents and sustained campaigns. The digital harassment I've documented doesn't fit the Snyder protection because it involves coordinated, sustained, personalized attacks designed not to contribute to public debate, but to silence and terrorize. The dynamic in the courtroom was shifting perceptibly. Justices who had initially appeared skeptical were now fully engaged, several taking detailed notes. Court observers noted that Justice Clarence Thomas, who rarely spoke during oral arguments, was paying unusually close attention to Khalifa's responses. Justice Brett Kavanaugh entered the discussion. Your constitutional argument is compelling, Ms. Khalifa, but there's a practical concern. If we accept your framework for defining digital harassment as unprotected speech, how do we prevent this from becoming a tool for censoring legitimate criticism? The Internet thrives on robust, often harsh debate. Thank you for that question, Justice Kavanaugh. Khalifa responded with growing authority. I'm not suggesting the court should eliminate robust online debate. I'm proposing that the court recognize a distinction between legitimate criticism and coordinated harassment campaigns designed to terrorize individuals into silence. She referenced her prepared materials seamlessly. The key distinguishing factors are coordination, repetition, personalization, and intent to harm rather than persuade. When hundreds of individuals coordinate to repeatedly send threatening messages, share private information, and create a sustained campaign of intimidation that crosses the line from protected criticism into unprotected harassment. Chief Justice Roberts, clearly surprised by Khalifa's command of constitutional doctrine, attempted a different approach. Your brief cites several international law precedents and comparative constitutional analysis from other democracies. How can we be confident that foreign approaches to balancing free speech with harassment protections are compatible with our First Amendment tradition? It was exactly the kind of question designed to expose superficial research. Roberts suspected Khalifa might have included international references without understanding their implications for American constitutional law. Khalifa smiled slightly, recognizing the challenge. "I'm glad you raised that point, Chief Justice Roberts. Far from suggesting we adopt foreign approaches wholesale, I cite international precedents to demonstrate that robust democracies can protect both free speech and individual safety through carefully crafted legal frameworks." From memory, she outlined how the German Constitutional Court, the Canadian Supreme Court, and the European Court of Human Rights had each developed sophisticated approaches to balancing expression rights with protection from harassment, explaining how their reasoning could inform but not dictate American constitutional interpretation. Justice Elena Kagan, visibly impressed, interjected, "Ms. Khalifa, your comparative analysis is remarkable. Did you conduct this research personally, or did you work with constitutional scholars to develop these arguments?" For the first time, Khalifa showed a hint of personal pride. "Justice Kagan, while I certainly studied the work of leading scholars, the comparative research examining foreign court decisions, analyzing their constitutional frameworks, understanding their cultural contexts, I conducted personally during my legal studies at American University and in the years since graduation." A buzz ran through the courtroom. Many observers were learning for the first time that Khalifa had legitimate legal credentials, and her sophisticated comparative constitutional analysis was entirely her own work. Chief Justice Roberts, whose earlier dismissiveness now seemed inappropriate, shifted uncomfortably in his chair. Justice Sotomayor seized the opening to move the discussion forward. "Ms. Khalifa, returning to the case at hand, how would your proposed framework apply to the specific harassment campaign you experienced? Walk us through how your constitutional analysis would work in practice." Khalifa turned directly to address Justice Sotomayor with obvious relief at the opportunity to discuss the practical application of her legal theory. "Justice Sotomayor, under the framework I've outlined, the harassment campaign against me fails constitutional protection on multiple grounds." She methodically outlined her analysis. First, the campaign was coordinated, with participants sharing my personal information, coordinating timing of attacks, and amplifying each other's threatening messages. Second, the content was highly personalized, including threats of physical violence, sharing of private images without consent, and targeted harassment of my family members. Third, the clear intent was intimidation and silencing rather than contributing to any legitimate public debate. She paused, then delivered her most powerful point. "Perhaps most importantly, this harassment violates the Equal Protection Clause because it disproportionately targets women, particularly women who have been involved in adult entertainment. The current legal framework provides inadequate protection, effectively creating a second-class citizenship for women who face coordinated digital harassment." As Khalifa's argument gained momentum, court officers discreetly extended her allotted time, a rare courtesy that signaled the justice's deep engagement with her presentation. Chief Justice Roberts, now fully attentive, recognized that far from embarrassing Khalifa, he had inadvertently provided her with the perfect platform to demonstrate extraordinary legal acumen. The stakes had escalated far beyond the initial confrontation. What began as an attempt to highlight the presumed inadequacy of a celebrity's legal understanding had transformed into a serious reconsideration of First Amendment doctrine in the digital age. And Khalifa wasn't finished yet. Justice Amy Coney Barrett, who had been listening intently throughout the argument, spoke up with a question that reflected genuine intellectual curiosity, a sign that Khalifa's arguments were being taken seriously at the highest level. Ms. Khalifa, your brief makes a fascinating textual argument about the relationship between the First Amendment's free speech protections and the 14th Amendment's equal protection clause that I don't believe any scholar has previously developed. Could you elaborate on that constitutional theory? The question reflected not skepticism, but genuine academic interest. Justice Barrett, herself a former constitutional law professor, was engaging with Khalifa as an intellectual peer rather than a celebrity seeking attention. Thank you for that question, Justice Barrett, Khalifa replied, her confidence now unmistakable. While these constitutional provisions are typically analyzed separately, the historical evidence suggests the Reconstruction era Congress understood civil rights protections holistically. When government fails to protect certain groups from sustained campaigns of intimidation and silencing, it violates both the Free Speech Clause by creating a chilling effect and the Equal Protection Clause by providing an equal protection of fundamental rights. She continued with growing authority. The 14th Amendment's framers, particularly John Bingham and Thaddeus Stevens, wrote extensively about the interconnection between equal protection and meaningful participation in democratic discourse. A legal framework that effectively allows certain groups to be silenced through coordinated harassment creates exactly the kind of second-class citizenship the 14th Amendment was designed to prevent. Khalifa reached into her portfolio and removed photocopies of historical documents. I took the liberty of researching the original congressional debates during the drafting of the 14th Amendment. These documents, which haven't been cited in previous harassment cases, show that the framers explicitly connected equal protection with the ability to participate fully in public discourse without fear of intimidation. Justice Thomas, who had remained silent but deeply engaged throughout the argument, finally spoke a rare occurrence that caused reporters to lean forward in their seats. Ms. Khalifa, your originalist approach to constitutional interpretation is noteworthy. You've shown that digital harassment extends far beyond the protection intended by the First Amendment's framers. But I'm curious, how would you distinguish legitimate criticism of public figures from the harassment you're describing? The question went to the heart of one of the most complex areas of First Amendment law, the distinction between protected criticism of public figures and unprotected harassment. It was exactly the kind of nuanced inquiry that separated sophisticated constitutional analysis from superficial arguments. Khalifa responded with precision that demonstrated her deep understanding of the court's precedents. Justice Thomas, while I became a public figure through my brief career in adult entertainment, the harassment I've documented extends far beyond legitimate criticism of my public actions or statements. The key distinction lies in both content and intent. She held up her notes, organized with tabs for easy reference. Legitimate criticism addresses my public statements, my commentary on sports, or my advocacy positions. It contributes to public discourse, even when harsh or unflattering. But the harassment I've documented includes threats of physical violence, distribution of private information, coordination to target my family members, and sustained campaigns designed not to criticize but to terrorize and silence. Khalifa continued her analysis. Moreover, the Supreme Court's precedent in New York Times v. Sullivan established heightened protection for criticism of public figures precisely to encourage robust public discourse. But when speech crosses from criticism to intimidation, it defeats Sullivan's purpose by chilling rather than encouraging democratic participation. This nuanced response, respecting institutional concerns while advancing her constitutional argument, demonstrated Khalifa's sophisticated understanding of how constitutional doctrine evolved and how the court balanced competing values. Chief Justice Roberts, now fully engaged with the substance of Khalifa's position rather than her credentials, posed a final question that indicated serious consideration of her arguments. Miss Khalifa, if we were to accept your constitutional framework, what specific legal standard would you have us adopt for distinguishing protected speech from unprotected digital harassment? It was the kind of question typically reserved for the most respected advocates, an invitation to help shape constitutional doctrine, rather than merely argue a position. The packed courtroom recognized the significance of this shift in tone and approach. Khalifa didn't hesitate. Chief Justice Roberts, I would propose a three-part test rooted in First Amendment precedent and adapted for digital communication. She held up 3 fingers, counting off each element with the confidence of someone who had spent years developing this framework. First, courts should examine whether the speech involves coordination among multiple participants designed to amplify intimidation rather than contribute individual perspectives to public debate. Second, courts should assess whether the speech is designed to contribute to legitimate public discourse or to cause severe emotional distress and silence the target. Third, courts should consider whether the speech targets individuals for who they are rather than what they've said or done in public contexts. Khalifa concluded with quiet authority. This approach honors First Amendment text, aligns with historical precedent, provides clear guidance to lower courts, and protects Americans from digital age forms of harassment while preserving the robust debate essential to democracy. As Khalifa's allotted time officially expired, something extraordinary happened. Instead of the customary interruption announcing, "Your time has expired," there was a moment of complete silence in the courtroom. Several justices continued taking notes. Others sat back visibly processing what they had heard. Finally, Chief Justice Roberts spoke, his tone markedly different from his initial intervention. "Thank you, Ms. Khalifa. Your argument has been exceptionally well prepared and thoroughly researched." The simple acknowledgement carried unmistakable subtext, a recognition that Roberts' attempt to question Khalifa's qualifications had backfired completely, instead revealing a legal mind of remarkable capacity and preparation. As Khalifa gathered her materials and returned to her seat, the opposing counsel approached the podium, looking visibly shaken. The dynamic of the case had shifted fundamentally. What began as what many expected would be a routine defense of current legal frameworks had transformed into an uphill battle against a constitutional theory that had clearly resonated with justices across the ideological spectrum. Legal reporters in the courtroom immediately recognized they were witnessing a historic argument, one that might reshape constitutional doctrine while challenging assumptions about who belongs in the legal profession's most prestigious venues. The aftermath of what quickly became known as the Khalifa argument spread through legal and cultural circles with unprecedented speed. Within hours, constitutional law professors were adding the oral argument transcript to their syllabi. Legal scholars across the ideological spectrum weighed in, many expressing surprise and admiration for the depth of Khalifa's constitutional analysis. CNN legal analyst Jeffrey Toobin delivered perhaps the most succinct assessment. "I've covered the Supreme Court for over 20 years, and I've never seen anything quite like this." Mia Khalifa didn't just hold her own against the Chief Justice, she delivered what may be the most compelling argument for digital age First Amendment protections ever presented to the court. The following morning, hashtags like #constitutional-scholar Mia and #DigitAllRightSnow trended across social media platforms. Clips of Khalifa citing obscure congressional debates and reciting constitutional precedents from memory circulated widely, garnering millions of views. A generation that knew her primarily from her adult film career and sports commentary discovered a new dimension to their understanding of her capabilities. 3 days after the argument, the New York Times published a feature revealing details about Khalifa's legal education that had previously remained private. According to the article, Khalifa had completed her GD at American University Washington College of Law with highest honors, studying part-time while maintaining her careers in sports commentary and social media advocacy. She never wanted special treatment, said Professor Jennifer Martinez, who taught Khalifa's constitutional law course. Most students had no idea who was sitting next to them. For the first semester, she was just another exceptional student with a passion for civil rights and digital privacy law. She brought unique real-world experience to our discussions of how constitutional principles apply to modern challenges. The article revealed that Khalifa had funded scholarships for law students from underrepresented backgrounds and had been actively involved in the law school's civil rights clinic, providing legal assistance to victims of online harassment. Her legal studies had been motivated by her personal experience with digital harassment and a desire to contribute substantively to legal protections for vulnerable individuals in the Internet age. Legal blogs and podcasts dissected every aspect of the oral argument. Particular attention focused on Chief Justice Roberts' initial dismissive comment and how dramatically the dynamic had shifted once Khalifa demonstrated her constitutional expertise. Court watchers noted that Roberts had grown increasingly respectful as the argument progressed, eventually engaging with Khalifa as an intellectual peer rather than a celebrity interloper. What we witnessed was a real-time recalibration of assumptions, said Nina Totenberg on NPR's Morning Edition. The Chief Justice clearly expected to find a dilettante seeking publicity and instead discovered a brilliant legal mind. His evolution during those 30 minutes teaches us something important about preconceptions and the danger of judging intellectual capacity based on someone's past career choices. The professional legal community's response was equally significant. The American Bar Association invited Khalifa to deliver the keynote address at its annual conference on digital rights and constitutional law. Law school applications from women and minorities increased by 47% following the widely publicized argument, with many applicants citing Khalifa's example as inspiration for pursuing legal careers despite unconventional backgrounds. Khalifa herself maintained characteristic humility in her limited public comments. When approached by reporters at a charity event supporting digital literacy, she simply stated, "Constitutional law, like any discipline, rewards thorough preparation and genuine commitment to justice. I'm grateful the court gave me the opportunity to present arguments that could help protect vulnerable individuals from digital harassment, and I hope their decision advances both free speech and human dignity." 8 weeks after oral argument, the Supreme Court issued its opinion in Khalifa v. Digital Media Consortium. In a surprising 7-2 decision, the court ruled in Khalifa's favor, establishing new constitutional protections against coordinated digital harassment, while maintaining robust First Amendment protections for legitimate speech. Chief Justice Roberts assigned himself the majority opinion, a choice many court observers interpreted as a gracious acknowledgment of his initial misjudgment. Roberts wrote, "The digital age has created new forms of speech that challenge traditional First Amendment categories. After careful consideration of constitutional text, historical precedent, and the practical realities of online communication, we conclude that coordinated digital harassment campaigns designed to silence and terrorize individuals fall outside First Amendment protection." In an unprecedented move, the opinion directly quoted Khalifa's oral argument 6 times and adopted her 3-part test for distinguishing protected criticism from unprotected harassment. A footnote specifically commended petitioner's exceptionally thorough constitutional analysis and historical research that illuminated founding-era understandings of free speech protections. Justice Thomas wrote a concurring opinion that went even further, calling for comprehensive reconsideration of how First Amendment doctrine applied to digital communication. Justice Sotomayor's concurrence emphasized the equal protection dimensions of digital harassment, citing statistics Khalifa had provided about the disproportionate targeting of women and minorities. Perhaps most remarkably, Chief Justice Roberts added a personal observation in the final paragraph of the majority opinion. This case reminds us that constitutional wisdom can emerge from unexpected experiences, and that our legal system is strengthened when diverse voices contribute to our understanding of how foundational principles apply to modern challenges. The court benefited greatly from the thorough advocacy and innovative constitutional analysis provided by petitioner. The practical impact of the decision was immediate and far-reaching. Within months, social media platforms updated their terms of service to comply with the new constitutional framework. Law enforcement agencies received training on investigating digital harassment under the court's new standards. Several states passed legislation providing additional protections for harassment victims based on the constitutional framework Khalifa had developed. For Khalifa personally, the experience opened an entirely new chapter in her already diverse career. While she continued her work in sports commentary and social media advocacy, she also established the Digital Rights Defense Initiative, a nonprofit organization providing legal representation to individuals facing coordinated online harassment. Several leading law schools invited her to deliver guest lectures on constitutional law in the digital age. Harvard Law School created the Khalifa Fellowship in Digital Civil Rights, supporting students researching the intersection of technology and constitutional protections. 6 months after the decision, Khalifa and Chief Justice Roberts appeared together at a Georgetown Law School symposium on constitutional adaptation in the digital age. Their discussion, marked by mutual respect and intellectual engagement, demonstrated how adversarial legal proceedings could ultimately advance understanding when conducted with integrity and thorough preparation. Roberts acknowledged publicly what many had observed privately. Miss Khalifa taught me a valuable lesson that day. Never confuse someone's past career with their intellectual capacity. Never assume that unconventional paths to legal knowledge are less valid than traditional ones. Her argument in our case will be studied by constitutional scholars and law students for generations to come. Khalifa responded with characteristic grace. The beauty of our constitutional system, when it functions as intended, is that arguments stand or fall on their merits, not on the background of those who make them. I'm grateful the court was willing to engage seriously with the constitutional issues facing individuals in the digital age, regardless of who brought those issues to their attention. The exchange, widely shared across social media and featured in law school curricula, became a powerful symbol of how preconceptions could be overcome through preparation, perseverance, and the courage to speak truth to power. In classrooms, courtrooms, and public discourse across America, the story of how a former adult film actress had transformed Supreme Court doctrine through brilliant constitutional analysis became a modern parable about judgment, opportunity, and the ongoing American struggle to create a legal system where ideas truly matter more than identity. The case established Khalifa as one of the most important constitutional advocates of her generation, while fundamentally changing how courts approach the balance between free speech and protection from harassment in the digital age. More importantly, it proved that in America, intellectual brilliance and legal wisdom can emerge from the most unexpected places, and that our democracy is strongest when we judge arguments by their merit rather than their source. Thank you for watching this remarkable story of constitutional triumph and intellectual courage. If you found this account of legal brilliance and preparation inspiring, please hit the like button and subscribe to our channel for more stories of justice, perseverance, and unexpected excellence. Leave a comment below with your thoughts on how we can better recognize and celebrate intellectual achievement, regardless of someone's background or past career choices.